Hello friends, Namaskaram. Today we will discuss Section 20 of Prevention of Corruption Act, not theoretically but practically. If you are an accused of an offence punishable under Section 7 or Section 11 of PC Act, in that scenario, Section 20 of PC Act might be a trouble for you. You have to understand the subject so that whenever you are having the case under Section 7 or Section 11, then you could easily contest the issue without getting any trouble or worry. For this, I am going to discuss this topic in the practical way. I request all of you at the inception to maintain a proper notebook with pen or pencil so that you could easily understand the subject and could review your file in light of principles which are going to be awarded by me. First of all, we have to note down Section 20 of PCA. It is basically concerned with presumption, where public servant accepts any undue advantage. The term undue advantage is defined. The term acceptance is not defined. The term public servant is defined. Apart from that, the term presumption is not defined in PC8, but it is defined in Bharatiya Sakshya Adhiniyam. Apart from that, the term public servant is also defined in Bharatiya Nyaya Sanhita. It is called BNS. So we have to add two important points. It is applicable not only for the case of acceptance but also for the case of demand. And apart from that, we have to understand that basically it is a presumption which can be rebutted. For this, the accused is required to raise a probable defense. To be noted that the presumption is applicable in case of trial. When there is no trial means you are going to contest the case on bail, quashing, discharge, presumption would not be applicable. For application of presumption, there is a requirement of trial. No trial, no presumption. It must be concerned with offence punishable under Section 7 or Section 11. So if you are having a case under Section 8, 9, 10, 12, 13, 14, 15, it would not be applicable. Only for Section 7 or Section 11. The third condition is that it must be proved that we have to understand the said concept. As per judgment of Honorable Supreme Court, case title is Neeraj Datta versus State of NCT. Judgment date is 15th of December 2022. To draw the presumption, the concerned prosecution is bound to have a prima facie case on record. If the elements of demand, acceptance, recovery are not on record in that scenario, it could not be said that prima facie a case is said to be proved. So, the duty is of prosecution to bring on record the basis of violation, and that's why it is used that the concerned prosecution is duty bound to prove that a public servant accused of an offence. So, if you are a private person, Section 7 of PC8 would not be applicable on you. In that scenario, Section 20 PC8 presumption would not be applicable. But if you are a public servant accused of an offence and it is proved that you has accepted. To know the acceptance, again we have to study the judgment of Honorable Supreme Court Neeraj Datta versus State of NCT. In that case, it is specified that to constitute the proper acceptance on the part of concerned accused, there must be evidence on record that the concerned complainant entirely offered and the concerned accused voluntarily accepted. So the acceptance must be voluntarily. If it is not voluntarily, presumption would not be drawn. Apart from that, obtained means directly he demanded and taken. That is called obtained. And apart from that, attempt to obtain means a mere demand. But it must have a connection with the concerned official function. But to be noted that if a case is based merely on demand, In that scenario, section 17A of PC Act is quite important. If there is no compliance of section 17A of PC Act in that scenario, the proceedings vitiate and liable to be quashed. The said view is approved by Honorable Rajasthan High Court in an important judgment titled as Rani Dahan versus State of Rajasthan. Judgment date is 8th of October 2024. Apart from that, we are having judgment of Honorable Delhi High Court and Honorable Karnataka High Court and Honorable Supreme Court on that point as well. If it is proved that he has accepted or obtained or attempt to obtain for himself, or it might be any other person, but the key point is that there must be evidence on record that he has accepted or obtained or attempt to obtain any undue advantage. Mere demand, mere recovery, mere acceptance cannot connect the accused with crime. To be noted that mere recovery, mere acceptance is not sufficient. Demand is must. Sometimes it is seen that the demand is not raised on the part of accused, rather than AI tool is used to implicate the concerned accused by generating a fabricated voice. Apart from that, the complete transcription is not done. Apart from that, certain words are added in the transcription so that the case could be fabricated, and that's why in that scenario you may rely on an important judgment of Honorable Karnataka High Court Mahesh PS versus State of Karnataka. Judgment date is 24th of May 2023. When all the criteria are fulfilled, only when presumption would be drawn. And in consequence of presumption, it will be presumed that you had accepted or obtained or attempt to obtain that undue advantage as a motive or reward under section 7 for performing or cause performance of a public duty improperly or dishonestly. Apart from that, it may be concerned with you or with another public servant, as the case may be. Apart from that, if the undue advantage is in kind, means there is no money transaction, which is called consideration, in that scenario section 11 would be applicable. It is totally immaterial whether the consideration is adequate or inadequate. So when the transaction is in money, section 7 would be applicable, and when it is in kinds, in that scenario section 11 would be applicable. Now the important question arises how to rebut the presumption. As we know that in a case under PC Act, demand is sine qua non. If there is no demand, no presumption could be drawn. Number 2, if there is only recovery and acceptance but there is no demand, no presumption could be drawn. Apart from that, we have to raise a probable defense to rebut the presumption. For example, there is submission on part of you that the voice is not of you, basically it is a probable voice. As we know that we are having judgment of Honorable Delhi High Court Ajay versus State of NCT. Judgment date is 28 October 2022. In that case, it is observed that if the voice is probable, in that scenario conviction could not be stand. So by relying on that principle, we may chalk out the case for probable defense and could convince the concerned court to draw adverse inference against the concerned prosecution so that the presumption could be rebutted. To be noted that if there is recovery from your person, then you have to give the explanation, otherwise presumption of section 119 of BSA or section 114 of Indian Evidence Act would be withdrawn. So to rebut the same, you have to set up a specific theory. Apart from that, we have to give the representation at the inception, so that if on your points that concerned IO totally failed to investigate, in that scenario we could take the advantage of unfair investigation. So I think that I am totally able to cause all of you to understand the basis of section 20 of PC Act and how to work on it effectively and efficiently. See you in the next video. Till then, Jai Hind, Jai Bharat.